Hello, everyone. Today's case is Students for Fair Admissions versus Harvard. So, this is the most recent evolution of affirmative action. So, let's see what they said. Harvard College and the University of North Carolina, UNC, are two of the oldest institutions of higher learning in the United States. Every year, tens of thousands of students apply to each school. Many fewer are admitted. Both Harvard and UNC employ a highly selective admissions process to make their decisions. Admission to each school can depend on a student's grades, recommendation letters, or extracurricular involvement. It can also depend on their race. The question presented is whether the admission systems used by Harvard College and UNC are lawful under the Equal Protection Clause of the 14th Amendment. At Harvard, each application for admission is initially screened by a first reader, who assigns a numerical score in each of 6 categories: academic, extracurricular, athletic, school support, personal, and overall. For the overall category, a composite of the 5 other ratings, a first reader can and does consider the applicant's race. Harvard's admissions subcommittees then review all applications from a particular geographic area. These regional subcommittees make recommendations to the full admissions committee, and they take an applicant's race into account. When the 40-member full admissions committee begins its deliberations, it discusses the relative breakdown of applicants by race. The goal of the process, according to Harvard's director of admissions, is ensuring there is no dramatic drop off in minority admissions from the prior class. An applicant receiving a majority of the full committee's votes is tentatively accepted for admission. At the end of the process, the racial composition of the tentative applicant pool is disclosed to the committee. The last stage of Harvard's admissions process, called the LOP, winnows the list of tentatively admitted students to arrive at the final class. Applicants that Harvard considers cutting at this stage are placed on the LOP list, which contains only 4 pieces of information: legacy status, recruited athlete status, financial aid eligibility, and race. In the Harvard admissions process, race is the determinative tip for a significant percentage of all admitted African American and Hispanic applicants. UNC has a similar admissions process. Every application is reviewed first by an admissions office reader who assigns a numerical rating to each of several categories. Readers are required to consider the applicant's race as a factor in their review. Readers then make a written recommendation on each assigned application, and they may provide an applicant a substantial plus depending on the applicant's race. At this stage, most recommendations are provisionally final. A committee of experienced staff members then conducts a school group review of every initial decision made by a reader and either approves or rejects the recommendation. In making those decisions, the committee may consider the applicant's race. Petitioner Students for Fair Admissions, SFFA, is a nonprofit organization whose stated purpose is to defend human and civil rights secured by law, including the right of individuals to equal protection under the law. SFFA filed separate lawsuits against Harvard and UNC, arguing that their race-based admissions programs violate, respectively, Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause of the 14th Amendment. After separate bench trials, both admissions programs were found permissible under the Equal Protection Clause and this court's precedents. In the Harvard case, the First Circuit affirmed, and this court granted certiorari. In the UNC case, this court granted certiorari before judgment. Held. Harvard's and UNC's admissions program violate the Equal Protection Clause of the 14th Amendment. Because SFFA complies with the standing requirements for organizational plaintiffs articulated by this court in Hunt v. Washington State Apple Advertising Commission, SFFA's obligations under Article 3 are satisfied, and this court has jurisdiction to consider the merits of SFFA's claims. The court rejects UNC's argument that SFFA lacks standing because it is not a genuine membership organization. An organizational plaintiff can satisfy Article 3 jurisdiction in 2 ways, one of which is to assert standing solely as the representative of its members, an approach known as representational or organizational standing. To invoke it, an organization must satisfy the 3-part test in Hunt. Respondents do not suggest that SFFA fails Hunt's test for organizational standing. They argue instead that SFFA cannot invoke organizational standing at all because SFFA was not a genuine membership organization at the time it filed suit. Respondents maintain that under Hunt, a group qualifies as a genuine membership organization only if it is controlled and funded by its members. In Hunt, this court determined that a state agency with no traditional members could still qualify as a genuine membership organization in substance because the agency represented the interests of individuals and otherwise satisfied Hunt's three-part test for organizational standing. Hunt's indicia of membership analysis, however, has no applicability here. As the courts below found, SFFA is indisputably a voluntary membership organization with identifiable members who support its mission and whom SFFA represents in good faith. SFFA is thus entitled to rely on the organizational standing doctrine as articulated in Hunt. Proposed by Congress and ratified by the states in the wake of the Civil War, the 14th Amendment provides that no state shall deny to any person the equal protection of the laws. Proponents of the Equal Protection Clause described its foundational principle as not permitting any distinctions of law based on race or color, any law which operates upon one man. They maintained should operate equally upon all. Accordingly, as this court's early decisions interpreted the Equal Protection Clause explained, the 14th Amendment guaranteed that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states. Despite the early recognition of the broad sweep of the Equal Protection Clause, the court, alongside the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state-mandated segregation was in many parts of the nation a regrettable norm. This court played its own role in that ignoble history, allowing in Plessy v. Ferguson the separate but equal regime that would come to deface much of America. After Plessy, American courts labored with the doctrine of separate but equal for over half a century. Some cases in this period attempted to curtail the perniciousness of the doctrine by emphasizing that it required states to provide black students educational opportunities equal to, even if formally separate from, those enjoyed by white students. But the inherent folly of that approach, of trying to derive equality from inequality, soon became apparent. As the court subsequently recognized, even racial distinctions that were argued to have no palpable effect worked to subordinate the afflicted students. By 1950, the inevitable truth of the 14th Amendment had thus begun to re-emerge. Separate cannot be equal. The culmination of this approach came finally in Brown v. Board of Education. There, the court overturned the separate but equal regime established in Plessy and began on the path of invalidating all de jure racial discrimination by the states and federal government. The conclusion reached by the Brown court was unmistakably clear. The right to a public education must be made available to all on equal terms. The court reiterated that rule just 1 year later, holding that full compliance with Brown required schools to admit students on a racially non-discriminatory basis. In the years that followed, Brown's fundamental principle that racial discrimination in public education is unconstitutional reached other areas of life. For example, state and local laws requiring segregation in busing, Gale v. Browder, racial segregation in the employment of public beaches and bathhouses, Mayor and City Council of Baltimore v. Dawson, and anti-miscegenation laws, Loving v. Virginia. These decisions and others like them reflect the core purpose of the Equal Protection Clause, doing away with all governmentally imposed discrimination based on race. Eliminating racial discrimination means eliminating all of it. Accordingly, the court has held that the Equal Protection Clause applies without regard to any difference of race, of color, or of nationality. It is universal in its application. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. Any exceptions to the Equal Protection Clause's guarantee must survive a daunting two-step examination known as strict scrutiny, which asks first whether the racial classification is used to further compelling governmental interests, and second, whether the government's use of race is narrowly tailored, i.e. necessary, to achieve that interest. Acceptance of race-based state action is rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. This court first considered whether a university may make race-based admissions decisions in Bakke, In a deeply splintered decision that produced 6 different opinions, Justice Powell's opinion for himself alone would eventually come to serve as the touchstone for constitutional analysis of race-conscious admissions policies. After rejecting 3 of the university's 4 justifications as not sufficiently compelling, Justice Powell turned to its last interest asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body. Justice Powell found that interest to be a constitutionally permissible goal for an institution of higher education, which was entitled as a matter of academic freedom to make its own judgments as to the selection of its student body. But a university's freedom was not unlimited. Racial and ethnic distinctions of any sort are inherently suspect, Justice Powell explained, and antipathy toward them was deeply rooted in our nation's constitutional and demographic history. Accordingly, a university could not employ a 2-track quota system with a specific number of seats reserved for individuals from a preferred ethnic group. Neither still could a university use race to foreclose an individual from all consideration. Race could only operate as a plus in a particular applicant's file, and even then it had to be weighed in a manner flexible enough to consider all pertinent elements of diversity in light of the particular qualifications of each applicant. For years following Bakke, lower courts struggled to determine whether Justice Powell's decision was binding precedent. Then, in Grutter v. Bollinger, the court for the first time endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use of race in university admissions. The Grutter majority's analysis tracked Justice Powell's in many respects, including its insistence on limits on how universities may consider race in their admissions programs. Those limits, Grutter explained, were intended to guard against 2 dangers that all race-based government action portends. The first is the risk that the use of race will devolve into illegitimate stereotyping. Admissions programs could thus not operate on the belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. The second risk is that race would be used not as a plus but as a negative, to discriminate against those racial groups that were not the beneficiaries of the race-based preference. A university's use of race, accordingly, could not occur in a manner that unduly harmed non-minority applicants. To manage these concerns, Grutter imposed one final limit on race-based admissions programs. At some point, the court held, they must end. Recognizing that enshrining a permanent justification for racial preferences would offend the Constitution's unambiguous guarantee of equal protection, the court expressed its expectation that in 25 years, the use of racial preferences will no longer be necessary to further the interest approved today. 20 years have passed since Grutter, with no end to race-based college admissions in sight. But the court has permitted race-based college admissions only within the confines of narrow restrictions. Such admissions programs must comply with strict scrutiny, may never use race as a stereotype or negative, and must at some point end. Respondents' admission systems fail each of these criteria and must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. Respondents fail to operate their race-based admissions programs in a manner that is sufficiently measurable to permit judicial review under the rubric of strict scrutiny. First, the interests that respondents view as compelling cannot be subjected to meaningful judicial review. Those interests include training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, and preparing engaged and productive citizens. While these are commendable goals, they are not sufficiently coherent for purposes of strict scrutiny. It is unclear how courts are supposed to measure any of these goals, or if they could, to know when they have been reached so that racial preferences can end. The elusiveness of respondents' asserted goals is further illustrated by comparing them to recognized compelling interests. For example, courts can discern whether the temporary racial segregation of inmates will prevent harm to those in the prison. But the question whether a particular mix of minority students produces engaged and productive citizens, or effectively trains future leaders, is standardless. Second, respondents' admissions programs fail to articulate a meaningful connection between the means they employ and the goals they pursue. To achieve the educational benefits of diversity, respondents measure the racial composition of their classes using racial categories that are plainly overbroad, expressing, for example, no concern whether South Asian or East Asian students are adequately represented as Asian. Arbitrary or undefined, the use of the category Hispanic, or under-inclusive, no category at all for Middle Eastern students. The unclear connection between the goals that respondents seek and the means they employ preclude courts from meaningfully scrutinizing respondents' admissions programs. The university's main response to these criticisms is trust us. They assert that universities are owed deference when using race to benefit some applicants but not others. While this court has recognized a tradition of giving a degree of deference to a university's academic decisions, it has made clear that deference must exist within constitutionally prescribed limits. Respondents have failed to present an exceedingly persuasive justification for separating students on the basis of race that is measurable and concrete enough to permit judicial review, as the Equal Protection Clause requires. Respondents' race-based admission systems also fail to comply with the Equal Protection Clause's twin commands that race may never be used as a negative and that it may not operate as a stereotype. The First Circuit found that Harvard's consideration of race has resulted in fewer admissions of Asian American students. Respondents' assertion that race is never a negative factor in their admissions programs cannot withstand scrutiny. College admissions are zero-sum, and a benefit provided to some applicants but not to others necessarily advantages the former at the expense of the latter. Respondents' admissions programs are infirm for a second reason as well. They require stereotyping, the very thing Grutter forswore. When a university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike. Such stereotyping is contrary to the core purpose of the Equal Protection Clause. Respondents' admissions programs also lack a logical endpoint as Grutter required. Respondents suggest that the end of race-based admissions programs will occur once meaningful representation and diversity are achieved on college campuses. Such measures of success amount to little more than comparing the racial breakdown of the incoming class and comparing it to some other metric, such as the racial makeup of the previous incoming class or the population in general, to see whether some proportional goal has been reached. The problem with this approach is well established. Outright racial balancing is patently unconstitutional. Respondents' second proffered endpoint, when students receive the educational benefits of diversity, fares no better. As explained, it is unclear how a court is supposed to determine if or when such goals would be adequately met. Third, respondents suggest the 25-year expectation in Grutter means that race-based preferences must be allowed to continue until at least 2028. The court's statement in Grutter, however, reflected only that court's expectation that race-based preferences would, by 2028, be unnecessary in the context of racial diversity on college campuses. Finally, respondents argue that the frequent reviews they conduct to determine whether racial preferences are still necessary obviates the need for an endpoint. But Grutter never suggested that periodic review can make unconstitutional conduct constitutional. Because Harvard's and UNC's admissions programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints, those admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. At the same time, nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as the discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university. Many universities have for too long wrongly concluded that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. This nation's constitutional history does not tolerate that choice. Reversed. Chief Justice Roberts delivered the opinion of the court, in which Thomas, Alito, Gorsuch, Kavanaugh, and Barrett joined. Thomas filed a concurring opinion. Gorsuch filed a concurring opinion, in which Thomas joined. Kavanaugh filed a concurring opinion. Sotomayor filed a dissenting opinion, in which Kagan joined, and in which Jackson joined, as it applies to number 21-707. Jackson filed a dissenting opinion in number 21-707, in which Sotomayor and Kagan joined. Jackson took no part in the consideration or decision of the case in number 20-1199. Chief Justice Roberts delivered the opinion of the court. In these cases, we consider whether the admission systems used by Harvard College and the University of North Carolina, two of the oldest institutions of higher learning in the United States, are lawful under the Equal Protection Clause of the 14th Amendment. Founded in 1636, Harvard College is one of the most selective Harvard College has one of the most selective application processes in the country. Over 60,000 people applied to the school last year. Fewer than 2,000 were admitted. Gaining admission to Harvard is thus no easy feat. It can depend on having excellent grades, glowing recommendation letters, or overcoming significant adversity. It can also depend on your race. The admissions process at Harvard works as follows. Every application is initially screened by a first reader, who assigns scores in 6 categories: academic, extracurricular, athletic, school support, personal, and overall. A rating of 1 is the best, a rating of 6 the worst. In the academic category, for example, a 1 signifies near perfect standardized test scores and grades. In the extracurricular category, it indicates truly unusual achievement, and in the personal category, it denotes outstanding attributes like maturity, integrity, leadership, kindness, and courage. A score of 1 on the overall rating, a composite of the 5 other ratings, signifies an exceptional candidate with more than 90% chance of admission. In assigning the overall rating, the first readers can and do take an applicant's race into account. Once the first read process is complete, Harvard convenes admissions subcommittees. Each subcommittee meets for 3 to 5 days and evaluates all applicants from a particular geographic area. The subcommittees are responsible for making recommendations to the full admissions committee. The subcommittees can and do take an applicant's race into account when making their recommendations. The next step of the Harvard process is the full committee meeting. The committee has 40 members, and its discussion centers around the applicants who have been recommended by the regional subcommittees. At the beginning of the meeting, the committee discusses the relative breakdown of applicants by race. The goal, according to Harvard's Director of Admissions, is to make sure that Harvard does not have a dramatic drop-off in minority admissions from a prior class. Each applicant considered by the full committee is discussed one by one, and every member of the committee must vote on admission. Only when an applicant secures a majority of the full committee's votes is he or she tentatively accepted for admission. At the end of the full committee meeting, the racial composition of the pool of tentatively admitted students is disclosed to the committee. The final stage of Harvard's process is called the LOP, during which the list of tentatively admitted students is winnowed further to arrive at the final class. Any applicants that Harvard considers cutting at this stage are placed on the LOP list, which contains only 4 pieces of information: legacy status, recruited athlete status, financial aid eligibility, and race. The full committee decides as a group which students to LOP. In doing so, the committee can and does take race into account. Once the LOP process is complete, Harvard's admitted class is set. In the Harvard admissions process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. Founded shortly after the Constitution was ratified, the University of North Carolina, UNC, prides itself on being the nation's first public university. Like Harvard, UNC's admissions process is highly selective. In a typical year, the school receives approximately 43,500 applications for its freshman class of 4,200. Every application the university receives is initially reviewed by one of approximately 40 admissions office readers, each of whom reviews roughly 5 applications per hour. Readers are required to consider race and ethnicity as one factor in their review. Other factors include academic performance and rigor, standardized testing results, extracurricular involvement, essay quality, personal factors, and student background. Readers are responsible for providing numerical ratings for the academic, extracurricular, personal, and essay categories. During the years at issue in this litigation, underrepresented minority students were more likely to score highly on their personal ratings than their white and Asian American peers, but were more likely to be rated lower by UNC readers on their academic program, academic performance, extracurricular activities, and essays. After assessing an applicant's materials along these lines, the reader formulates an opinion about whether the student should be offered admission, and then writes a comment defending his or her recommended decision. In making that decision, readers may offer students a plus based on their race, which may be significant in an individual case. The admissions decisions made by the first readers are, in most cases, provisionally final. Following the first read process, applications then go to a process called school group review, where a committee composed of experienced staff members reviews every initial decision. The review committee receives a report on each student, which contains, among other things, their class rank, GPA, and test scores, the rating assigned to them by their initial readers, and their status as residents, legacies, or special recruits. The review committee either approves or rejects each admission recommendation made by the first reader, after which the admissions decisions are finalized. In making those decisions, the review committee may also consider the applicant's race. Petitioner Students for Fair Admissions, SFFA, is a nonprofit organization founded in 2014 whose purpose is to defend human and civil rights secured by law, including the right of individuals to equal protection under the law. In November 2014, SFFA filed separate lawsuits against Harvard College and the University of North Carolina, arguing that their race-based admissions programs violated, respectively, Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause of the 14th Amendment. The district courts in both cases held bench trials to evaluate SFFA's claims. Trial in the Harvard case lasted 15 days and included testimony from 30 witnesses, after which the court concluded that Harvard's admissions program comported with our precedents on the use of race in college admissions. The First Circuit affirmed that determination. Similarly, in the UNC case, the district court concluded after an 8-day trial that UNC's admissions program was permissible under the Equal Protection Clause. We granted certiorari in the Harvard case and certiorari before judgment in the UNC case. Before turning to the merits, we must assure ourselves of our jurisdiction. UNC argues that SFFA lacks standing to bring its claims because it is not a genuine membership organization. Every court to have considered this argument has rejected it, and so do we. Article 3 of the Constitution limits the judicial power of the United States to cases or controversies, ensuring that federal courts act only as a necessity in the determination of real, earnest, and vital disputes. To state a case or controversy under Article 3, a plaintiff must establish standing. That, in turn, requires a plaintiff to demonstrate that it has 1. Suffered an injury in fact, 2. That is fairly traceable to the challenged conduct of the defendant, and 3. That is likely to be redressed by a favorable judicial decision. In cases like these, where the plaintiff is an organization, the standing requirements of Article 3 can be satisfied in 2 ways. Either the organization can claim that it suffered an injury in its own right, or alternatively, it can assert standing solely as the representative of its members. The latter approach is known as representational or organizational standing. To invoke it, an organization must demonstrate that A. its members would otherwise have standing to sue in their own right, B. the interests it seeks to protect are germane to the organization's purpose, and C. neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. Respondents do not contest that SFFA satisfies the 3-part test for organizational standing articulated in Hunt, and like the courts below, we find no basis in the record to conclude otherwise. Respondents instead argue that SFFA was not a genuine membership organization when it filed suit, and thus that it could not invoke the doctrine of organizational standing in the first place. According to respondents, our decision in Hunt established that groups qualify as genuine membership organizations only if they are controlled and funded by their members. And because SFFA's members did neither at the time this litigation commenced, respondents' argument goes, SFFA could not represent its members for purposes of Article 3 standing. Hunt involved the Washington State Apple Advertising Commission, a state agency whose purpose was to protect the local Apple industry. The commission brought suit challenging a North Carolina statute that imposed a labeling requirement on containers of apples sold in that state. The commission argued that it had standing to challenge the requirement on behalf of Washington's Apple industry. We recognized, however, that as a state agency, the commission was not a traditional voluntary membership organization, for it had no members at all. As a result, we could not easily apply the 3-part test for organizational standing, which asks whether an organization's members have standing. We nevertheless concluded that the commission had standing because the apple growers and dealers it represented were effectively members of the commission. The growers and dealers alone elected the members of the commission, alone served on the commission, and alone financed its activities. They possessed, in other words, all of the indicia of membership. The Commission was therefore a genuine membership organization in substance, if not in form, and it was clearly entitled to rely on the doctrine of organizational standing under the three-part test recounted above. The indicia of membership analysis employed in Hunt has no applicability in these cases. Here, SFFA is indisputably a voluntary membership organization with identifiable members. It is not, as in Hunt, a state agency that conceitedly has no members. As the First Circuit in the Harvard litigation observed, at the time SFFA filed suit, it was a validly incorporated 501c3 nonprofit with 47 members who joined voluntarily to support its mission. Meanwhile, in the UNC litigation, SFFA represented four members in particular, high school graduates who were denied admission to UNC. Those members filed declarations with the district court stating that they have voluntarily joined SFFA, they support its mission, they receive updates about the status of the case from SFFA's president, and they have had the opportunity to have input and direction on SFFA's case. Whereas here, an organization has identified members and represents them in good faith, our cases do not require further scrutiny into how the organization operates. Because SFFA complies with the standing requirements demanded of organizational plaintiffs in Hunt, its obligations under Article 3 are satisfied. In the wake of the Civil War, Congress proposed and the states ratified the 14th Amendment, providing that no state shall deny to any person the equal protection of the laws. To its proponents, the Equal Protection Clause represented a foundational principle, the absolute equality of all citizens of the United States politically and civilly before their own laws. The Constitution, they were determined, should not permit any distinctions of law based on race or color. Because any law which operates upon one man should operate equally upon all. As soon-to-be President James Garfield observed, the 14th Amendment would hold over every American citizen, without regard to color, the protecting shield of law. And in doing so, said Senator Jacob Howard of Michigan, the amendment would give to the humblest, the poorest, and most despised of the race the same rights and the same protection before the law as it gives the most powerful, the most wealthy, or the most haughty. For without this principle of equal justice, Howard continued, there is no Republican government and none that is really worth maintaining. At first, this court embraced the transcendent aims of the Equal Protection Clause. What is this, we said, of the clause in 1880, but declaring that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states. The broad and benign provisions of the 14th Amendment apply to all persons, we unanimously declared 6 years later. It is hostility to race and nationality, which in the eye of the law is not justified. Despite our early recognition of the broad sweep of the Equal Protection Clause, this court, alongside the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state-mandated segregation was in many parts of the nation a regrettable norm. This court played its own role in that ignoble history, allowing in Plessy v. Ferguson the separate but equal regime that would come to deface much of America. The aspirations of the framers of the Equal Protection Clause, virtually strangled in their infancy, would remain for too long only that aspirations. After Plessy, American courts labored with the doctrine of separate but equal for over half a century. Some cases in this period attempted to curtail the perniciousness of the doctrine by emphasizing that it required states to provide black students educational opportunities equal to, even if formally separate from, those enjoyed by white students. See, for example, Missouri ex rel. Gaines v. Canada. The admissibility of laws separating the races in the enjoyment of privileges afforded by the states rest wholly upon the equality of the privileges which the laws give to the separated groups. But the inherent folly of that approach, of trying to derive equality from inequality, soon became apparent. As the court subsequently recognized, even racial distinctions that were argued to have no palpable effect worked to subordinate the afflicted students. See, for example, McLaurin versus Oklahoma State Regents for Higher Education. It is said that the separations imposed by the state in this case are in form merely nominal, but they signify that the state sets petitioner apart from the other students. By 1950, the inevitable truth of the 14th Amendment had thus begun to reemerge. Separate cannot be equal. The culmination of this approach came finally in Brown v. Board of Education. In that seminal decision, we overturned Plessy for good and set firmly on the path of invalidating all de jure racial discrimination by the states and federal government. Brown concerned the permissibility of racial segregation in public schools. The school district maintained that such segregation was lawful because the schools provided to black students and white students were of roughly the same quality. But we held such segregation impermissible even though the physical facilities and other tangible factors may be equal. The mere act of separating children because of their race, we explained, itself generated a feeling of inferiority. The conclusion reached by the Brown Court was thus unmistakably clear. The right to a public education must be made available to all on equal terms. As the plaintiffs had argued, no state has any authority under the Equal Protection Clause of the 14th Amendment to use race as a factor in affording educational opportunities among its citizens. The court reiterated that rule just 1 year later, holding that full compliance with Brown required schools to admit students on a racially non discriminatory basis. The time for making distinctions based on race had passed. Brown, the court observed, declared the fundamental principle that racial discrimination in public education is unconstitutional. So too in other areas of life. Immediately after Brown, we began routinely affirming lower court decisions that invalidated all manner of race based state action. In Gale v. Browder, for example, we summarily affirmed a decision invalidating state and local laws that required segregation in busing. As the lower court explained, the Equal Protection Clause requires equality of treatment before the law for all persons without regard to race or color. And in Mayor and City Council of Baltimore v. Dawson, we summarily affirmed a decision striking down racial segregation at public beaches and bathhouses maintained by the state of Maryland and the city of Baltimore. It is obvious that racial segregation in recreational activities can no longer be sustained, the lower court observed. The ideal of equality before the law, which characterizes our institutions, demanded as much. In the decades that followed, this court continued to vindicate the Constitution's pledge of racial equality. Laws dividing parks and golf courses, neighborhoods and businesses, buses and trains, schools and juries were undone, all by a transformative promise stemming from our American ideal of fairness. The Constitution forbids discrimination by the general government or by the states against any citizen because of his race. As we recounted in striking down the state of Virginia's ban on interracial marriage 13 years after Brown, the 14th Amendment proscribes all invidious racial discriminations. Our cases had thus consistently denied the constitutionality of measures which restrict the rights of citizens on account of race. See also Yikwo for commercial property, Shelley v. Kramer, housing covenants, Hernandez v. Texas, composition of juries, Dawson, beaches and bathhouses, Holmes v. Atlanta, golf courses, Browder, busing, New Orleans City Park Improvement Association v. Detige, public parks, Bailey v. Patterson, transportation facilities, Swan v. Charlotte Mecklenburg Board of Education, for education, and then Batson v. Kentucky for preemptory jury strikes. These decisions reflect the core purpose of the Equal Protection Clause, doing away with all governmentally imposed discrimination based on race. We have recognized that repeatedly. The clear and central purpose of the 14th Amendment was to eliminate all official state sources of invidious racial discrimination in the states. See also Washington v. Davis. The central purpose of the Equal Protection Clause of the 14th Amendment is the prevention of official conduct discriminating on the basis of race. And then McLaughlin v. Florida. The historical fact is that the central purpose of the 14th Amendment was to eliminate racial discrimination. Eliminating racial discrimination means eliminating all of it, and the Equal Protection Clause, we have accordingly held, applies without regard to any differences of race, of color, or of nationality. It is universal in its application. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. Any exception to the Constitution's demand for equal protection must survive a daunting two-step examination known in our cases as strict scrutiny. Under that standard, we ask first whether the racial classification is used to further compelling governmental interests. Second, if so, we ask whether the government's use of race is narrowly tailored, meaning necessary, to achieve that interest. Outside the circumstances of these cases, our precedents have identified only two compelling interests that permit resort to race based government action. One is remediating specific, identified instances of past discrimination that violated the Constitution or a statute. The second is avoiding imminent and serious risks to human safety in prisons, such as a race riot. Our acceptance of race based state action has been rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. That principle cannot be overridden except in the most extraordinary case. These cases involve whether a university may make admissions decisions that turn on an applicant's race. Our court first considered that issue in Regents of the University of California v. Bakke, which involved a set-aside admissions program used by the University of California Davis Medical School. Each year, the school held 16 of its 100 seats open for members of certain minority groups who were reviewed on a special admissions track separate from those in the main admissions pool. The plaintiff, Alan Bakke, was denied admission 2 years in a row, despite the admission of minority applicants with lower grade point averages and MCAT scores. Bakke subsequently sued the school, arguing that its set aside program violated the Equal Protection Clause. In a deeply splintered decision that produced 6 different opinions, none of which commanded a majority of the court, we ultimately ruled in part in favor of the school and in part in favor of Bakke. Justice Powell announced the court's judgment, and his opinion, though written for himself alone, would eventually come to serve as the touchstone for constitutional analysis of race conscious admissions policies. Justice Powell began by finding 3 of the school's 4 justifications for its policy not sufficiently compelling. The school's first justification of reducing the historical deficit of traditionally disfavored minorities in medical schools, he wrote, was akin to preferring members of any one group for no reason other than race or ethnic origin. Yet that was discrimination for its own sake, which the Constitution forbids. Justice Powell next observed that the goal of remedying the effects of societal discrimination was also insufficient because it was an amorphous concept of injury that may be ageless in its reach into the past. Finally, Justice Powell found that there was virtually no evidence in the record indicating that the school's special admissions program would, as the school had argued, increase the number of doctors working in underserved areas. Justice Powell then turned to the school's last interest asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body. That interest, in his view, was a constitutionally permissible goal for an institution of higher education, and that was so, he opined, because a university was entitled as a matter of academic freedom to make its own judgments as to the selection of its student body. But a university's freedom was not unlimited. Racial and ethnic distinctions of any sort are inherently suspect, Justice Powell explained, and antipathy toward them was deeply rooted in our nation's constitutional and demographic history. A university could not employ a quota system, for example, reserving a specified number of seats in each class for individuals from the preferred ethnic groups. Nor could it impose a multi-track program with a prescribed number of seats set aside for each identifiable category of applicants. And neither still could it use race to foreclose an individual from all consideration simply because he was not the right color. The role of race had to be cabined. It could not operate only as a plus in a particular applicant's file, and even then, race was to be weighed in a manner flexible enough to consider all pertinent elements of diversity in light of the particular qualifications of each applicant. Justice Powell derived this approach from what he called the illuminating example of the admissions system then used by Harvard College. Under that system, as described by Harvard in a brief it had filed with the court, the race of an applicant may tip the balance in his favor, just as geographic origin or a life experience may tip the balance in other candidates' cases. Harvard continued, a farm boy from Idaho can bring something to Harvard College that a Bostonian cannot offer. Similarly, a black student can usually bring something that a white person cannot offer. The result, Harvard proclaimed, was that race has been and should be a factor in some admissions decisions. No other member of the court joined Justice Powell's opinion. 4 justices instead would have held that the government may use race for the purposes of remedying the effects of past societal discrimination. 4 other justices, meanwhile, would have struck down the Davis program as violative of Title VI. In their view, it seemed clear that the proponents of Title VI assumed that the Constitution itself required a colorblind standard on the part of government. The Davis program, therefore, flatly contravened a core principle embedded in the constitutional and moral understanding of the times, the prohibition against racial discrimination. In the years that followed our fractured decision in Bakke, lower courts struggled to discern whether Justice Powell's opinion constituted binding precedent. We accordingly took up the matter again in 2003 in the case Grutter v. Bollinger, which concerned the admission system used by the University of Michigan Law School. There, in another sharply divided decision, the court for the first time endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use of race in university admissions. The court's analysis tracked Justice Powell's in many respects, and for a compelling interest, the court held that the law school's educational judgment that such diversity is essential to its educational mission is one to which we defer. In achieving that goal, however, the court made clear, just as Justice Powell had, that the law school was limited in the means that it could pursue. The school could not establish quotas for members of certain racial groups or put members of those groups on separate admissions tracks. Neither could it insulate applicants who belong to certain racial or ethnic groups from the competition for admission, nor still could it desire some specified percentage of a particular group merely because of its race or ethnic origin. These limits, Grutter explained, were intended to guard against two dangers that all race-based government action portends. The first is the risk that the use of race will devolve into illegitimate stereotyping. Universities were thus not permitted to operate their admissions programs on the belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. The second risk is that race would be used not as a plus, but as a negative, to discriminate against those racial groups that were not the beneficiaries of the race-based preference. A university's use of race, accordingly, could not occur in a manner that unduly harmed non-minority applicants. But even with these constraints in place, Grutter expressed marked discomfort with the use of race in college admissions. The court stressed the fundamental principle that there are serious problems of justice connected with the idea of racial preference itself. It observed that all racial classifications, however compelling their goals, were dangerous, and it cautioned that all race-based governmental action should remain subject to continuing oversight to assure that it will work the least harm possible to other innocent persons competing for the benefit. To manage these concerns, Grutter imposed one final limit on race-based admissions programs. At some point, the court held, they must end. This requirement was critical, and Grutter emphasized it repeatedly. All race-conscious admissions programs must have a termination point. They must have reasonable durational limits. They must be limited in time. They must have sunset provisions. They must have a logical endpoint. Their deviation from the norm of equal treatment must be a temporary matter. The importance of an endpoint was not just a matter of repetition. It was the reason the court was willing to dispense temporarily with the Constitution's unambiguous guarantee of equal protection. The court recognized as much. Enshrining a permanent justification for racial preferences, the court explained, would offend this fundamental equal protection principle. For the proposition that it would be a sad day indeed were America to become a quota-ridden society, with each identifiable minority assigned proportional representation in every desirable walk of life. Grutter thus concluded with the following caution. It has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. 20 years later, no end in sight. Harvard's review about when race-based admissions will end doesn't have a date on it. Neither does UNC's, yet both insist that the use of race in their admissions program must continue. But we have permitted race-based admissions only within the confines of narrow restrictions. University programs must comply with strict scrutiny. They may never use race as a stereotype or negative, and at some point they must end. Respondents' admission systems, however well-intentioned and implemented in good faith, fail each of these criteria. They must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. Because racial discrimination is invidious in all contexts, we have required that universities operate their race-based admissions programs in a manner that is sufficiently measurable to permit judicial review under the rubric of strict scrutiny. Classifying and assigning students based on their race requires more than an amorphous end to justify it. Respondents have fallen short of satisfying that burden. First, the interests they view as compelling cannot be subjected to meaningful judicial review. Harvard identifies the following educational benefits that it is pursuing: 1. Training future leaders in the public and private sectors; 2. Preparing graduates to adapt to an increasingly pluralistic society; 3. Better educating its students through diversity; and 4. Producing new knowledge stemming from diverse outlooks. UNC points to similar benefits, namely 1. Promoting the robust exchange of ideas; 2. Broadening and refining understanding; 3. Fostering innovation and problem solving; 4. Preparing engaged and productive citizens and leaders; and 5. Enhancing appreciation, respect, and empathy, cross-racial understanding, and breaking down stereotypes. Although these are commendable goals, they are not sufficiently coherent for purposes of strict scrutiny. At the outset, it is unclear how courts are supposed to measure any of these goals. How is a court to know whether leaders have been adequately trained, whether the exchange of ideas is robust, or whether new knowledge is being developed? Even if these goals could somehow be measured, moreover, how is a court to know when they have been reached, and when the perilous remedy of racial preferences may cease? There is no particular point at which there exists sufficient innovation and problem solving, or students who are appropriately engaged and productive. Finally, the question in this context is not one of no diversity or of some, it is a question of degree. How many fewer leaders Harvard would create without racial preferences, or how much poorer the education at Harvard would be, are inquiries no court could resolve. Comparing respondents' asserted goals to interests we have recognized as compelling further illustrates their elusive nature. In the context of racial violence in a prison, for example, courts can ask whether temporary racial segregation of inmates will prevent harm to those in the prison. When it comes to workplace discrimination, courts can ask whether a race-based benefit makes members of the discriminated class whole for the injuries they suffered. And in school segregation cases, courts can determine whether any race-based remedial action produces a distribution of students comparable to what it would have been in the absence of such constitutional violations. Nothing like that is possible when it comes to evaluating the interests respondents assert here. Unlike discerning whether a prisoner will be injured or whether an employee should receive back pay, the question whether a particular mix of minority students produces engaged and productive citizens, sufficiently enhances appreciation, respect, and empathy, or effectively trains future leaders, is standardless. The interests that respondents seek, though plainly worthy, are inescapably imponderable. Second, respondents' admissions programs fail to articulate a meaningful connection between the means they employ and the goals they pursue. To achieve the educational benefits of diversity, UNC works to avoid the underrepresentation of minority groups, while Harvard, likewise, guards against inadvertent drop offs in representation of certain minority groups from year to year. To accomplish both of those goals, in turn, the universities measure the racial composition of their classes using the following categories: 1. Asian; 2. Native Hawaiian or Pacific Islander; 3. Hispanic; 4. White; 5. African American; and 6. Native American. It is far from evident, though, how assigning students to these racial categories and making admissions decisions based on them furthers the educational benefits that the universities claim to pursue. For starters, the categories are themselves imprecise in many ways. Some of them are plainly overbroad. By grouping together all Asian students, for instance, respondents are apparently uninterested in whether South Asian or East Asian students are adequately represented, so long as there is enough of one to compensate for a lack of the other. Meanwhile, other racial categories, such as Hispanic, are arbitrary or undefined. Let's see, for example, Lopez and Krogstad, Pew Research Center for who is Hispanic, referencing the long history of changing labels and shifting categories, reflecting evolving cultural norms about what it means to be Hispanic or Latino in the United States today. And still other categories are underinclusive. When asked at oral argument how are applicants from Middle Eastern countries classified, such as Jordan, Iraq, Iran, and Egypt, UNC's counsel responded, "I do not know the answer to that question." See Gorsuch concurring from the oral argument, detailing the incoherent and irrational stereotypes that these racial categories further. Indeed, the use of these opaque racial categories undermines instead of promotes respondents' goals. By focusing on underrepresentation, respondents would apparently prefer a class with 15% of students from Mexico over a class with 10% of students from several Latin American countries, simply because the former contains more Hispanic students than the latter. Yet, it is hard to understand how a plan that could allow these results can be viewed as being concerned with achieving enrollment that is broadly diverse. And given the mismatch between the means respondents employ and the goals they seek, it is especially hard to understand how courts are supposed to scrutinize the admissions programs that respondents use. The university's main response to these criticisms is essentially trust us. None of the questions recited above need answering, they say, because universities are owed deference when using race to benefit some applicants but not others. It is true that our cases have recognized a tradition of giving a degree of deference to a university's academic decisions, but we have been unmistakably clear that any deference must exist within constitutionally prescribed limits, and that deference does not imply abandonment or abdication of judicial review. Universities may define their missions as they see fit. The Constitution defines ours. Courts may not license separating students on the basis of race without an exceedingly persuasive justification that is measurable and concrete enough to permit judicial review. As this court has repeatedly affirmed, racial classifications are simply too pernicious to permit any but the most exact connection between justification and classification. The program at issue here does not. The programs at issue here do not satisfy that standard. The race-based admission systems that respondents employ also fail to comply with the twin commands of the Equal Protection Clause that race may never be used as a negative and that it may not operate as a stereotype. First, our cases have stressed that an individual's race may never be used against him in the admissions process. Here, however, the First Circuit found that Harvard's consideration of race has led to an 11.1% decrease in the number of Asian Americans admitted to Harvard. And the district court observed that Harvard's policy of considering applicants' race overall results in fewer Asian Americans and white students being admitted. Overall results in fewer Asian American and white students being admitted. Respondents nonetheless contend that an individual's race is never a negative factor in their admissions programs, but that assertion cannot withstand scrutiny. Harvard, for example, draws an analogy between race and other factors it considers in admission. While admissions officers may give a preference to applicants likely to excel in the Harvard Radcliffe Orchestra, Harvard explains, that does not mean it is a negative not to excel in a musical instrument. But on Harvard's logic, while it gives preferences to applicants with high grades and test scores, that does not mean it is a negative to be a student with lower grades and lower test scores. This understanding of the admissions process is hard to take seriously. College admissions are zero sum. A benefit provided to some applicants, but not to others, necessarily advantages the former group at the expense of the latter. Respondents also suggest that race is not a negative factor because it does not impact many admissions decisions. Yet, at the same time, respondents also maintain that the demographics of their admitted classes would meaningfully change if race-based admissions were abandoned. And they acknowledge that race is determinative for at least some, if not many, of the students they admit. How else but negative can race be described if, in its absence, members of some racial groups would be admitted in greater numbers than they otherwise would have been? The equal protection of the laws is not achieved through indiscriminate imposition of inequalities. Respondents' admissions programs are infirm for a second reason as well. We have long held that universities may not operate their admissions programs on the belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. That requirement is found throughout our Equal Protection Clause jurisprudence more generally. See, for example, Shoot v. Bam. In cautioning against impermissible racial stereotypes, this court has rejected the assumption that members of the same racial group, regardless of their age, education, economic status, or the community in which they live, think alike. Yet, by accepting race-based admissions programs in which some students may obtain preferences on the basis of race alone, respondents' programs tolerate the very thing that Grutter forswore, stereotyping. The point of respondents' admissions programs is that there is an inherent benefit in race qua race, in race for race's sake. Respondents admit as much. Harvard's admissions process rests on the pernicious stereotype that a black student can usually bring something that a white person cannot offer. UNC is much the same. It argues that race in itself says something about who you are. See the transcript of oral argument, analogizing being of a certain race to being from a rural area. We have time and again forcefully rejected the notion that government actors may intentionally allocate preference to those who may have little in common with one another but the color of their skin. The entire point of the Equal Protection Clause is that treating someone differently because of their skin color is not like treating them differently because they are from a city or from a suburb, or because they play the violin poorly or well. One of the principal reasons race is treated as a forbidden classification is that it demeans the dignity and worth of a person to be judged by ancestry instead of by his or her own merit and essential qualities. But when a university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike. At the very least, alike in the sense of being different from non minority students. In doing so, the university further stereotypes that treat the university furthers stereotypes that treat individuals as the product of their race, evaluating their thoughts and efforts, their very worth as citizens, according to a criterion barred to the government by history and the Constitution. Such stereotyping can only cause continued hurt and injury, contrary as it is to the core purpose of the Equal Protection Clause. If all this were not enough, respondents' admissions programs also lack a logical endpoint. Respondents and the government first suggest that respondents' race based admissions programs will end when, in their absence, there is meaningful representation and meaningful diversity on college campuses. The metric of meaningful representation, respondents assert, does not involve any strict numerical benchmark, or precise number or percentage, or specified percentage. So, what does it involve? Numbers all the same. At Harvard, each full committee meeting begins with a discussion of how the breakdown of the class compares to the prior year in terms of racial identities. And if at some point in the admissions process it appears that a group is notably underrepresented or has suffered a dramatic drop off relative to the prior year, the admissions committee may decide to give additional attention to applications from students within that group. See here in the finding of the district court, finding that Harvard uses race to track how each class is shaping up relative to previous years with an eye towards achieving a level of racial diversity. The results of the Harvard admissions process reflect this numerical commitment. For the admitted classes of 2009 to 2018, black students represented a tight band of 10% to 11.7% of the admitting pool. The same theme held true for other minority groups. UNC's admission program operates similarly. The university frames the challenge it faces as the admission and enrollment of underrepresented minorities, a metric that turns solely on whether a group's percentage enrollment within the underage student body is lower than their percentage within the general population in North Carolina. The university has not yet fully achieved its diversity-related educational goals. It explains in part due to its failure to obtain closer to proportional representation. The problem with these approaches is well established. Outright racial balancing is patently unconstitutional. That is so, we have repeatedly explained, because at the heart of the Constitution's guarantee of equal protection lies the simple command that the government must treat citizens as individuals, not as simply components of a racial, religious, sexual, or national class. By promising to terminate their use of race only when some rough percentage of various racial groups is admitted, respondents turn that principle on its head. Their admissions program effectively assure that race will always be relevant and that the ultimate goal of eliminating race as a criterion will never be achieved. Respondents' second proffered endpoint fares no better. Respondents assert that universities will no longer need to engage in race-based admissions when, in their absence, students nevertheless receive the educational benefits of diversity. But as we have already explained, it is not clear how a court is supposed to determine when stereotypes have broken down or productive citizens and leaders have been created. Nor is there any way to know whether those goals would adequately be met in the absence of a race-based admissions program. As UNC itself acknowledges, these qualitative standards are difficult to measure. See the transcript of oral argument, and also see Fisher, requiring race-based admissions programs to operate in a manner that is sufficiently measurable. Third, respondents suggest that race-based preferences must be allowed to continue for at least 5 more years, based on the court's statement in Grutter that it expected that 25 years from now, the use of racial preferences will no longer be necessary. The 25-year mark articulated in Grutter, however, reflected only that court's view that race-based preferences would by 2028 be unnecessary to ensure a requisite level of racial diversity on college campuses. That expectation was oversold. Neither Harvard nor UNC believes that race-based admissions will in fact be unnecessary in 5 years, and both universities thus expect to continue using race as a criterion well beyond the time limit that Grutter suggested. Indeed, the high school applicants that Harvard and UNC will evaluate this fall using their race-based admission systems are expected to graduate in 2028, 25 years after Grutter was decided. Finally, respondents argue that their programs need not have an endpoint at all because they frequently review them to determine whether they remain necessary. Respondents point to language in Grutter that they contend permits the durational requirement to be met with periodic reviews to determine whether racial preferences are still necessary to achieve student body diversity. But Grutter never suggested that periodic review could make unconstitutional conduct constitutional. To the contrary, the court made clear that race-based admissions programs eventually had to end, despite whatever periodic review universities conducted. Here, however, Harvard concedes that its race-based admissions program has no endpoint. See the brief of respondent. Harvard has not set a sunset date for its program, and it acknowledges that the way it thinks about the use of race in its admissions process is the same now as it was nearly 50 years ago. UNC's race-based admissions program is likewise not set to expire anytime soon, nor indeed any time at all. The university admits that it has not set forth a proposed time period in which it believes it can end all race-conscious admissions practices. And UNC suggests that it might soon use race to a greater extent than it currently does. In short, there is no reason to believe that respondents will, even acting in good faith, comply with the Equal Protection Clause anytime soon. The dissenting opinions resist these conclusions. They would instead uphold respondents' admissions programs based on their view that the 14th Amendment permits state actors to remedy the effects of societal discrimination through explicitly race-based measures. Although both opinions are thorough and thoughtful in many respects, this court has long rejected their core thesis. The dissent's interpretation of the Equal Protection Clause is not new. In Bakke, 4 justices would have permitted race-based admissions programs to remedy the effects of societal discrimination. See the joint opinion of Brennan, White, Marshall, and Blackmun, concurring in judgment in part and dissenting in part. But that minority view was just that, a minority view. Justice Powell, who provided the 5th vote and controlling opinion in Bakke, firmly rejected the notion that societal discrimination constituted a compelling interest. But such an interest presents an amorphous concept of injury that may be ageless in its reach into the past. It cannot justify a racial classification that imposes disadvantages upon persons who bear no responsibility for whatever harm the beneficiaries of the race-based admissions program are thought to have suffered. The court soon adopted Justice Powell's analysis as its own. In the years after Bakke, the court repeatedly held that ameliorating societal discrimination does not constitute a compelling interest that justifies race-based state action. An effort to alleviate the effects of societal discrimination is not a compelling interest, we said plainly in Hunt, a 1996 case about the Voting Rights Act. We reached the same conclusion in Crossan, a case that concerned a preferential government contracting program, permitting past societal discrimination to serve as the basis for rigid racial preferences would be to open the door to competing claims for remedial relief for every disadvantaged group. Opening that door would shutter another. The dream of a nation of equal citizens would be lost. We observed in a mosaic of shifting preferences based on inherently unmeasurable claims of past wrongs. Such a result would be contrary to both the letter and spirit of a constitutional provision whose central command is equality. The dissents here do not acknowledge any of this. They fail to cite Hunt. They fail to cite Crossan. They fail to mention that the entirety of their analysis of the Equal Protection Clause, the statistics, the cases, the history, has been considered and rejected before. There is a reason the principal dissent must invoke Justice Marshall's partial dissent in Bakke nearly a dozen times while mentioning Justice Powell's controlling opinion barely once. Justice Jackson's opinion ignores Justice Powell altogether. For what one dissent denigrates as rhetorical flourishes about colorblindness are in fact the proud pronouncements of cases like Loving and Yickwo, like Shelley and Bowling. They are defining statements of law. We understand the dissents want that law to be different. They are entitled to that desire. But they surely cannot claim the mantle of stare decisis while pursuing it. The dissents are no more faithful to our precedent on race-based admissions. To hear the principal dissent tell it, Grutter blessed such programs indefinitely until racial inequality will end. But Grutter did no such thing. It emphasized not once or twice, but at least 6 separate times, that race-based admissions programs must have reasonable durational limits and that their deviation from the norm of equal treatment must be a temporary matter. The court also disclaimed enshrining a permanent justification for racial preferences, yet the justification for race-based admissions that the dissent latches onto is just that, unceasing. The principal dissent's reliance on Fisher 2 is similarly mistaken. There, by a 4-3 vote, the court upheld a sui generis race-based admissions program used by the University of Texas, whose goal it was to enroll a critical mass of certain minority students. But neither Harvard nor UNC claims to be using the critical mass concept. Indeed, the universities admit they do not even know what it means. No one has directed anybody to achieve a critical mass, and I'm not even sure we would know what it is. Testimony of UNC administrator. Fisher 2 also recognized the enduring challenge that race-based admission systems place on the constitutional promise of equal treatment. The court thus reaffirmed the continuing obligation of universities to satisfy the burden of strict scrutiny. To drive the point home, Fisher 2 limited itself just as Grutter had in duration. The court stressed that its decision did not necessarily mean the university may rely on the same policy going forward. See also Fisher 1, recognizing that Grutter approved the plan at issue upon concluding that it was limited in time, and the court openly acknowledged that its decision offered limited prospective guidance. The principal dissent wrenches our case law from its context, going to lengths to ignore the parts of that law it does not like. The serious reservations that Bakke, Grutter, and Fisher had about racial preferences go unrecognized. The unambiguous requirements of the Equal Protection Clause, the most rigid, searching scrutiny it entails, go without note. And the repeated demands that race-based admissions programs must end go overlooked, contorted worse still, into a demand that such programs never stop. Most troubling of all is what the dissent must make these omissions to defend. Most troubling of all is what the dissent must make these omissions to defend. A judiciary that picks winners and losers based on the color of their skin. While the dissent would certainly not permit university programs that discriminated against Black and Latino applicants, it is perfectly willing to let the programs here continue. In its view, this court is supposed to tell state actors when they have picked the right races to benefit. Separate but equal is inherently unequal, said Brown. It depends, says the dissent. That is a remarkable view of the judicial role, remarkably wrong. Lost in the false pretense of judicial humility that the dissent espouses is a claim to power so radical, so destructive, that it required a second founding to undo. Justice Harlan knew better, one of the dissent's decrees. Indeed, he did. In the view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. For the reasons provided above, the Harvard and UNC admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions programs to work in that way, and we will not do so today. At the same time, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. But despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime we hold unlawful today. A dissenting opinion is generally not the best source of legal advice on how to comply with the majority opinion. What cannot be done directly cannot be done indirectly. The Constitution deals with substance, not shadows, and the prohibition against racial discrimination is leveled at the thing, not the name. Is leveled at the thing, not the name. A benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experiences as an individual, not on the basis of race. Many universities have for too long done just the opposite, and in doing so, they have concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice. The judgments of the Court of Appeals for the First Circuit and the District Court for the Middle District of North Carolina are reversed. It is so ordered. Justice Jackson took no part in the consideration or decision of the case in number 20-1199. Justice Thomas concurring. In the wake of the Civil War, the country focused its attention on restoring the Union and establishing the legal status of newly freed slaves. The Constitution was amended to abolish slavery and proclaim that all persons born in the United States are citizens, entitled to the privileges or immunities of citizenship and the equal protection of the laws. Because of that second founding, our Constitution is colorblind and neither knows nor tolerates classes among citizens. This court's commitment to that equality principle has ebbed and flowed over time. After forsaking the principle for decades, offering a judicial imprimatur to segregation, and ushering in the Jim Crow era, the court finally corrected course in Brown v. Board of Education, announcing that primary schools must either desegregate with all deliberate speed or else close their doors. It then pulled back in Grutter v. Bollinger, permitting universities to discriminate based on race in their admissions process, though only temporarily, in order to achieve alleged educational benefits of diversity. Yet the Constitution continues to embody a simple truth. Two discriminatory wrongs cannot make a right. I wrote separately in Grutter, explaining that the use of race in higher education admissions decisions, regardless of whether intended to help or to hurt, violates the 14th Amendment. In the decades since, I have repeatedly stated that Grutter was wrongly decided and should be overruled. Today, and despite a lengthy interregnum, the Constitution prevails. Because the court today applies genuine strict scrutiny to the race-conscious admissions policies employed at Harvard and the University of North Carolina, UNC, and finds that they fail that searching review, I join the majority opinion in full. I write separately to offer an originalist defense of the colorblind Constitution, to explain further the flaws of the court's Grutter jurisprudence, to clarify that all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution, and to emphasize the pernicious effects of all such discrimination. In the 1860s, Congress proposed and the states ratified the 13th and 14th Amendments, and with the authority conferred by these amendments, Congress passed two landmark civil rights acts. Throughout the debates on each of these measures, their proponents repeatedly affirmed their view of equal citizenship and the racial equality that flows from it. In fact, they held this principle so deeply that their crowning accomplishment, the 14th Amendment, ensures racial equality with no textual reference to race whatsoever. The history of these measures' enactment renders their motivating principle as clear as their text. All citizens of the United States, regardless of skin color, are equal before the law. I do not contend that all of the individuals who put forth and ratified the 14th Amendment universally believe this to be true. Some members of the proposing Congress, for example, oppose the amendment, and the historical record, particularly with respect to the debates on ratification in the states, is sparse. Nonetheless, substantial evidence suggests that the 14th Amendment was passed to establish the broad constitutional principle of full and complete equality of all persons under the law, forbidding all legal distinctions based on race or color. This was Justice Harlan's view in his lone dissent in Plessy, where he observed that our Constitution is colorblind. It was the view of the court in Brown which rejected any authority to use race as a factor in affording educational opportunities. And it is the view adopted in the court's opinion today, requiring the absolute equality of all citizens under the law. In its 1864 election platform, the Republican Party pledged to amend the Constitution to accomplish the utter and complete extirpation of slavery from the soil of the Republic. After their landslide victory, Republicans quickly moved to make good on that promise. Congress proposed what would become the 13th Amendment to the states in January 1865, and it was ratified as part of the Constitution later that year. The new amendment stated that neither slavery nor involuntary servitude shall exist in the United States except as a punishment for crime whereof the party shall have been duly convicted. It thus not only prohibited states from themselves enslaving persons, but also obligated them to end enslavement by private individuals within their borders. Its framers viewed the text broadly, arguing that it allowed Congress to legislate not merely against slavery itself, but against all the badges and relics of a slave system. The amendment also authorized Congress to enforce its terms by appropriate legislation, authority not granted in any prior amendment. Proponents believed this enforcement clause permitted legislative measures designed to accomplish the amendment's broader goal of equality for the freedmen. It quickly became clear, however, that further amendment would be necessary to safeguard that goal. Soon after the 13th Amendment's adoption, the reconstructed southern states began to enact black codes, which circumscribed the newly won freedoms of blacks. The Black Code of Mississippi, for example, imposed all sorts of disabilities on blacks, including limiting their freedom of movement and barring them from following certain occupations, owning firearms, serving on juries, testifying in cases involving whites, or voting. Congress responded with the landmark Civil Rights Act of 1866 in an attempt to preempt the Black Codes. The 1866 Act promised such a sweeping form of equality that it would lead many to say that it exceeded the scope of Congress's authority under the 13th Amendment. As enacted, it stated, "Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties, and to none other, any law, statute, ordinance, regulation, or custom, to the contrary notwithstanding." The text of the provision left no doubt as to its aim. All persons born in the United States were equal citizens entitled to the same rights and subject to the same penalties as white citizens in the categories enumerated. See McConnell, Originalism, and the Desegregation Decisions. Note that the bill neither forbade racial discrimination generally, nor did it guarantee particular rights to all persons. Rather, it required an equality in certain specific rights. And while the 1866 Act used the rights of white citizens as a benchmark, its rule was decidedly colorblind, safeguarding legal equality for all citizens of every race and color, and providing the same rights to all. The 1866 Act's evolution further highlights its rule of equality. To start, Dred Scott v. Sanford had previously held that blacks were not regarded as a portion of the people or citizens of the government and had no rights which the white man was bound to respect. The act, however, would effectively overrule Dred Scott and ensure the equality that had been promised to blacks. But the act went further still. On January 29, 1866, Senator Lyman Trumbull the bill's principal sponsor in the Senate, proposed text stating that all persons of African descent born in the United States are hereby declared to be citizens. The following day, Trumbull revised his proposal, removing the reference to African descent and declaring more broadly that all persons born in the United States are and not subject to any foreign power are citizens of the United States. In the years before the 14th Amendment's adoption, jurists and legislators often connected citizenship with equality, where the absence or presence of one entailed the absence or presence of the other. The addition of a citizenship guarantee thus evidenced an intent to broaden the provision, extending beyond recently freed blacks and incorporating a more general view of equality for all Americans. Indeed, the drafters later included a specific carve out for Indians not taxed, demonstrating the breadth of the bill's otherwise general citizenship language. As Trumbull explained, the provision created a bond between all Americans. Any statute which is not equal to all, and which deprives any citizen of civil rights which are secured to other citizens, was an unjust encroachment upon his liberty and a badge of servitude prohibited by the Constitution. Trumbull and most of the Act's other supporters identified the 13th Amendment as a principal source of constitutional authority for the Act's non-discrimination provisions. In particular, they explained that the 13th Amendment allowed Congress not merely to legislate against slavery itself, but also to counter measures which deprive any citizen of civil rights which are secured to other citizens. But opponents argued that Congress's authority did not sweep so broadly. President Andrew Johnson, for example, contended that Congress lacked authority to pass the measure, seizing on the breadth of the citizenship text and emphasizing state authority over matters of state citizenship. Consequently, doubts about the constitutional authority conferred by that measure led supporters to supplement their 13th Amendment arguments with other sources of constitutional authority. See Williams, Originalism and the Other Desegregation Decision, describing appeals to the naturalization power and the inherent power to protect the rights of citizens. As debates continued, it became increasingly apparent that safeguarding the 1866 Act, including its promise of black citizenship and the equal rights that citizenship entailed, would require further submission to the people of the United States in the form of a proposed constitutional amendment. Critically, many of those who believed that Congress lacked the authority to enact the 1866 Act also supported the principle of racial equality. So, almost immediately following the ratification of the 13th Amendment, several proposals for further amendments were submitted in Congress. One such proposal, approved by the Joint Committee on Reconstruction and then submitted to the House of Representatives on February 26, 1866, would have declared that the Congress shall have power to make all laws which shall be necessary and proper to secure to the citizens of each state all privileges and immunities of citizens in the several states, and to all persons in the several states equal protection in the rights of life, liberty, and property. Representative John Bingham, its drafter, was among those who believed Congress lacked the power to enact the 1866 Act. Specifically, he believed the very letter of the Constitution already required equality, but the enforcement of that requirement is of the reserved powers of the states. His proposed constitutional amendment, accordingly, would provide a clear constitutional basis for the 1866 Act and ensure that future Congresses would be unable to repeal it. Discussion of Bingham's initial draft was later postponed in the House, but the Joint Committee on Reconstruction continued its work. In April, Representative Thaddeus Stevens proposed to the Joint Committee an amendment that began, "No discrimination shall be made by any state nor by the United States as to the civil rights of persons because of race, color, or previous condition of servitude." Stevens' proposal was later revised to read as follows: "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." This revised text was submitted to the full House on April 30th, 1866. Like the eventual first section of the 14th Amendment, this proposal embodied the familiar privileges or immunities, due process, and equal protection clauses. And importantly, it also featured an enforcement clause with text borrowed from the 13th Amendment, conferring upon Congress the power to enforce its provisions. Stevens explained that the draft was intended to allow Congress to correct the unjust legislation of the states so far that the law which operates upon one man shall operate equally upon all. Moreover, Stevens later later statements indicate that he did not believe there was a difference in substance between the new proposal and earlier measures calling for impartial and equal treatment without regard to race. See U.S. Brown re-argument brief 44, noting a distinction only with respect to a suffrage provision. And Bingham argued that the need for the proposed text was one of the lessons that have been taught by the history of the past 4 years of terrific conflict during the Civil War. The proposal passed the House by a vote of 128 to 37. Senator Jacob Howard introduced the proposed amendment in the Senate, powerfully asking, "Ought not the time to be now passed when one measure of justice is to be meted out to a member of one caste, while another and a different measure is meted out to the member of another state?" Let me start over. Ought not the time to be now passed when one measure of justice is to be meted out to a member of one caste, while another and a different measure is meted out to the member of another caste, both castes being alike citizens of the United States, both bound to obey the same laws, to sustain the burdens of the same government, and both equally responsible to justice and to God for the deeds done in the body? In keeping with this view, he proposed an introductory sentence declaring that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. This text, the Citizenship Clause, was the final missing element of what would ultimately become subsection 1 of the 14th Amendment. Howard's draft for the proposed citizenship text was modeled on the Civil Rights Act of 1866's text, and he suggested the alternative language to remove all doubt as to what persons are or are not citizens of the United States, a question which had long been a great desideratum in the jurisprudence and legislation of this country. He further characterized the addition as simply declaratory of what I regard as the law of the land already. The proposal was approved by the Senate by a vote of 33 to 11. The House then reconciled differences between the two measures, approving the Senate's changes by a vote of 120 to 32. And in June 1866, the amendment was submitted to the states for their consideration and ratification. 2 years later, it was ratified by the requisite number of states and became the 14th Amendment to the United States Constitution. Its opening words instilled in our nation's Constitution a new birth of freedom. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. As enacted, the text of the 14th Amendment provides a firm statement of equality before the law. It begins by guaranteeing citizenship status, invoking the long-standing political and legal tradition that closely associated the status of citizenship with the entitlements to legal equality. It then confirms that states may not abridge the rights of national citizenship, including whatever civil equality is guaranteed to citizens under the Citizenship Clause. Finally, it pledges that even non-citizens must be treated equally as individuals and not as members of racial, ethnic, or religious groups. The drafters and ratifiers of the 14th Amendment focused on this broad equality idea, offering surprisingly little explanation of which terms was intended to accomplish which part of the amendment's overall goal. The available materials show, however, that there were widespread expressions of a general understanding of this broad scope of the amendment similar to that abundantly demonstrated in the congressional debates, namely that the first section of the amendment would establish the full constitutional right of all persons to equality before the law and would prohibit legal distinctions based on race or color. For example, the Pennsylvania debate suggests that the 14th Amendment was understood to make the law what justice is represented to be, blind, to the color of one's skin. The most commonly held view today, consistent with the rationale repeatedly invoked during the congressional debates, is that the amendment was designed to remove any doubts regarding Congress's authority to enact the Civil Rights Act of 1866 and to establish a non-discrimination rule that could not be repealed by future Congresses. See Harrison, Reconstructing the Privileges or Immunities Clause, noting that the primary purpose of the 14th Amendment was to mandate certain rules of racial equality, especially those contained in Section 1 of the Civil Rights Act of 1866. The amendment's phrasing supports this view that there does not appear to have been any argument to the contrary predating Brown. Consistent with the Civil Rights Act of 1866's aim, the amendment definitively overruled Chief Justice Taney's opinion in Dred Scott that blacks were not regarded as a portion of the people or citizens of the government and had no rights which the white man was bound to respect. And like the 1866 Act, the amendment also clarified that American citizenship conferred rights not just against the federal government, but also the government of the citizen's state of residence. Unlike the Civil Rights Act, however, the amendment employed a wholly race-neutral text, extending privileges or immunities to all citizens, even if its practical effect was to provide all citizens with the same privileges then enjoyed by whites. That citizenship guarantee was often linked with the concept of equality. Combining the citizenship guarantee with the Privileges or Immunities Clause and the Equal Protection Clause, the 14th Amendment ensures protection for all equal citizens of the nation without regard to race. Put succinctly, our Constitution is colorblind. In the period closely following the 14th Amendment's ratification, Congress passed several statutes designed to enforce its terms, eliminating government based black codes, systems of government imposed segregation, and criminalizing racially motivated violence. The marquee legislation was the Civil Rights Act of 1875, and the justifications offered by proponents of that measure are further evidence for the colorblind view of the 14th Amendment. The Civil Rights Act of 1875 sought to counteract the systems of racial segregation that had arisen in the wake of the Reconstruction era. Advocates of so-called separate but equal systems, which allowed segregated facilities for blacks and whites, had argued that laws permitting or requiring such segregation treated members of both races precisely alike. Blacks could not attend a white school, but symmetrically, whites could not attend a black school. C. Plessy, arguing that in light of the social circumstances at the time, racial segregation did not necessarily imply the inferiority of either race to the other. Congress was not persuaded. Supporters of the soon-to-be 1875 Act successfully countered that symmetrical restrictions did not constitute equality, as they did so on colorblind terms. For example, they asserted that free government demands the abolition of all distinctions founded on color and race, and they submitted that the time has come when all distinctions that grew out of slavery ought to disappear. See Congressional Globe, 42nd Congress. Second session, as long as you have distinctions and discriminations between white and black in the enjoyment of legal rights and privileges, you will have discontent and parties divided between black and white. Leading Republican Senator Charles Sumner compellingly argued that any rule excluding a man on account of his color is an indignity, an insult, and a wrong. I insist that by the law of the land, all persons without distinction of color shall be equal before the law. Far from conceding that segregation would be perceived as inoffensive if race roles were reversed, he declared that this is plain oppression, which you would feel keenly were it directed against you or your child. He went on to paraphrase the English common law rule to which he subscribed. The law makes no discrimination on account of color. Others echoed this view. Representative John Lynch declared that the duty of the lawmaker is to know no race, no color, no religion, no nationality, except to prevent distinctions on any of these grounds, so far as the law is concerned. Senator John Sherman believed that the route to peace was to wipe out all legal discriminations between white and black and make no distinction between black and white. And Senator Henry Wilson sought to make illegal all distinctions on account of color because there should be no distinction recognized by the laws of the land. And then see a statement of Representative Kane. Men are formed of God equally. The Civil Rights Bill simply declares this, that there shall be no discriminations between citizens of this land so far as the laws of the land are concerned. The view of the legislature was clear. The Constitution neither knows nor tolerates classes among citizens. The earliest Supreme Court opinions to interpret the 14th Amendment did so in colorblind terms. Their statements characterizing the amendment evidence is commitment to equal rights for all citizens, regardless of the color of their skin. In the slaughterhouse cases, the court identified the pervading purpose of the Reconstruction Amendments as the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freemen and citizen from the oppressions of those who had formerly exercised unlimited dominion over him. Yet the court quickly acknowledged that the language of the amendments did not suggest that no one else but the African American can share in this protection. Rather, if Mexican peonage or the Chinese coolie labor system shall develop slavery of the Mexican or Chinese race within our territory, the 13th Amendment may safely be trusted to make it void. And similarly, if other rights are assailed by the states which properly and necessarily fall within the protection of these articles, that protection will apply, though the party interested may not be of African descent. The court thus made clear that the 14th Amendment's equality guarantee applied to members of all races, including Asian Americans, ensuring all citizens equal treatment under the law. 7 years later, the court relied on the slaughterhouse view to conclude that the words of the 14th Amendment contain a necessary implication of a positive immunity, or right most valuable to the colored race, the right to exemption from unfriendly legislation against them distinctively as colored. The court thus found that the 14th Amendment banned express racial classifications, no matter the race affected, because these classifications are a stimulant to race prejudice. Similar statements appeared in other cases decided around that time. See Virginia v. Rives. The plain object of these statutes enacted to enforce the 14th Amendment, as of the Constitution which authorized them, was to place the colored race, in respect to civil rights, upon a level with whites. They made the rights and responsibilities, civil and criminal, of the two races exactly the same. And then see Ex parte Virginia. One great purpose of the 13th and 14th Amendments was to raise the colored race from that condition of inferiority and servitude in which most of them had previously stood, into perfect equality of civil rights, which all other persons within the jurisdiction of the states. This court's view of the 14th Amendment reached its nadir in Plessy, infamously concluding that the 14th Amendment could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality, or a commingling of the two races, or a commingling of the races upon terms unsatisfactory to either. That holding stood in sharp contrast to the court's earlier embrace of the 14th Amendment's equality ideal, as Justice Harlan emphasized in dissent. The Reconstruction Amendments had aimed to remove the race line from our systems of governments. For Justice Harlan, the Constitution was colorblind and categorically rejected laws designed to protect a dominant race, a superior class of citizens, while imposing a badge of servitude on others. History has vindicated Justice Harlan's view, and this court recently acknowledged that Plessy should have been overruled immediately because it betrayed our commitment to equality before the law. Nonetheless, and despite Justice Harlan's efforts, the era of state-sanctioned segregation persisted for more than a half century. Despite the extensive evidence favoring the colorblind view, as detailed above, it appears increasingly in vogue to embrace an anti-subordination view of the 14th Amendment, that the amendment forbids only laws that hurt, but not help, blacks. Such a theory lacks any basis in the original meaning of the 14th Amendment. Respondents cite a smattering of federal and state statutes passed during the years surrounding the ratification of the 14th Amendment, and Justice Sotomayor's dissent argues that several of these statutes evidence the ratifiers' understanding that the Equal Protection Clause permits consideration of race to achieve its goal. Upon examination, however, it is clear that these statutes are fully consistent with the colorblind view. Start with the 1865 Freedmen's Bureau Act. That act established the Freedmen's Bureau to issue provisions, clothing, and fuel needful for the immediate and temporary shelter and supply of destitute and suffering refugees and freedmen and their wives and children, and the setting apart for the use of loyal refugees and freedmen, abandoned, confiscated, or purchased lands, and assigning to every male citizen, whether refugee or freedman, not more than 40 acres of such land. The 1866 Freedmen's Bureau Act then expanded upon the prior year's law, authorizing the Bureau to care for all loyal refugees and freedmen. Importantly, however, the act applied to freedmen and refugees, a formerly race-neutral category, not blacks writ large. And because not all blacks in the United States were former slaves, freedmen was a decidedly under-inclusive proxy for race. Moreover, the Freedmen's Bureau served newly freed slaves alongside white refugees, and advocates of the law explicitly disclaimed any view rooted in modern conceptions of anti subordination. To the contrary, they explicitly clarified that the equality sought by the law was not one in which all men shall be 6 feet high. Rather, it strove to ensure that freedmen enjoy equal rights before the law, such that each man shall have the rights to pursue in his own way life, liberty, and happiness. Several additional federal laws cited by respondents appear to classify based on race rather than previous condition of servitude. For example, an 1866 law adopted special rules and procedures for the payment of colored servicemen in the Union Army to agents who helped them secure bounties, pensions, and other payments that they were due. At the time, however, Congress believed that many black servicemen were significantly overpaying for these agents' services, in part because the servicemen did not understand how the payment system operated. Thus, while this legislation appears to have provided a discrete race based benefit, its aim to prohibit race based exploitation may not have been possible at the time without using a racial screen. In other words, the statute's racial classifications may well have survived strict scrutiny. Another law, passed in 1867, provided funds for freedmen or destitute colored people in the District of Columbia. However, when a prior version of this law targeting only blacks was criticized for being racially discriminatory, it was defended on the grounds that there were various places in the city where former slaves lived in densely populated shantytowns. Congress thus may have enacted the measure not because of race, but rather to address a specific problem in shantytowns in the district where blacks lived. These laws, even if targeting race as such, likely were also constitutionally permissible examples of government action, undoing the effects of past discrimination in a way that does not involve classification by race, even though they had a racially disproportionate impact. The government can plainly remedy a race-based injury that it has inflicted, though such remedies must be meant to further a colorblind government, not to perpetuate racial consciousness. In that way, race based government measures during the 1860s and 1870s to remedy state enforced slavery were not inconsistent with the colorblind Constitution. Moreover, the very same Congress passed both these laws and the unambiguously worded Civil Rights Act of 1866 that clearly prohibited discrimination on the basis of race. And, as noted above, the proponents of these laws explicitly sought equal rights without regard to race while disavowing any anti subordination view. Justice Sotomayor argues otherwise, pointing to a number of race conscious federal laws passed around the time of the 14th Amendment's enactment. She identifies the Freedmen's Bureau Act of 1865, already discussed above, as one such law, but she admits that the programs did not benefit blacks exclusively. She also does not dispute that legislation targeting the needs of newly freed blacks in 1865 could be understood as directly remedial. Even today, nothing prevents the states from according an admissions preference to identified victims of discrimination. See Crossan, the opinion of Justice Scalia. While most of the beneficiaries might be black, neither the beneficiaries nor those disadvantaged by the preference would be identified on the basis of their race. Justice Sotomayor points also to the Civil Rights Act of 1866, which, as discussed above, mandates that all citizens have the same rights as those enjoyed by white citizens. But these references to the station of white citizens do not refute the view that the 14th Amendment is colorblind. Rather, they specify that in meeting the amendment's goal of equal citizenship, states must level up. The act did not single out a group of citizens for special treatment. Rather, all citizens were meant to be treated the same as those who, at the time, had the full rights of citizenship. Other provisions of the 1866 Act reinforce this view, providing for equality in civil rights. Most notably, subsection 14 stated that the basic civil rights of citizenship shall be secured without respect to race or color. And subsection 8 required that funds from land sales must be used to support schools without distinction of color or race in the parishes of the area where the land had been sold. In addition to these federal laws, Harvard also points to two state laws, a South Carolina statute that placed the burden of proof on the defendant when a colored or black plaintiff claimed a violation, and Kentucky legislation that authorized a county superintendent to aid African American paupers in Mercer County. Even if these statutes provided race based benefits, they do not support respondents and Justice Sotomayor's view that the 14th Amendment was contemporaneously understood to permit differential treatment based on race, prohibiting only caste legislation while authorizing anti subordination measures. At most, these laws would support the kinds of discrete remedial measures that our precedents have permitted. If services had been given only to white persons up to the 14th Amendment's adoption, then providing those same services only to previously excluded black persons would work to equalize treatment against a concrete baseline of government imposed inequality. It thus may have been the case that Kentucky's county specific race based public aid law was necessary because that particular county was not providing certain services to local poor blacks. Similarly, South Carolina's burden shifting framework, where the substantive rule being applied remained notably race neutral, may have been necessary to streamline litigation around the most commonly litigated type of case, a lawsuit seeking to remedy discrimination against a member of the large population of recently freed black Americans. See here the 1870s South Carolina Acts, documenting persistent racial discrimination by state licensed entities. Most importantly, however, there was a wide range of federal and state statutes enacted at the time of the 14th Amendment's adoption and during the period thereafter that explicitly sought to discriminate against blacks on the basis of race or a proxy for race. These laws, hallmarks of the race conscious Jim Crow era, are precisely the sort of enactments that the framers of the 14th Amendment sought to eradicate. Yet proponents of an anti subordination view necessarily do not take those laws as evidence of the 14th Amendment's true meaning. And rightly so. Neither those laws nor a number of laws that appeared to target blacks for preferred treatment displace the equality vision reflected in the history of the 14th Amendment's enactment. This is particularly true in light of the clear equality requirements present in the 14th Amendment's text. See New York Rifle and Pistol Association versus Bruin, noting that text controls over inconsistent post-ratification history. Properly understood, our precedents have largely adhered to the 14th Amendment's demand for colorblind laws. That is why, for example, courts must subject all racial classifications to the strictest of scrutiny. And in case after case, we have employed strict scrutiny vigorously to reject various forms of racial discrimination as unconstitutional. The court today rightly upholds the tradition and acknowledges the consequences that have flowed from Grutter's contrary approach. Three aspects of today's decision warrant comment. First, to satisfy strict scrutiny, universities must be able to establish an actual link between racial discrimination and educational benefits. Second, those engaged in racial discrimination do not deserve deference with respect to their reasons for discriminating. Third, attempts to remedy past governmental discrimination must be closely tailored to address that particular past governmental discrimination. To satisfy strict scrutiny, universities must be able to establish a compelling reason to racially discriminate. Grutter recognized only one interest sufficiently compelling to justify race-conscious admissions programs: the educational benefits of a diverse student body. Expanding on this theme, Harvard and UNC have offered a grab bag of interest to justify their programs, spanning from training future leaders in the public and private sectors to enhancing appreciation, respect, and empathy, with references to better educating their students through diversity in between. The court today finds that each of these interests are too vague and immeasurable to suffice. And I agree. Even in Grutter, the court failed to clearly define the educational benefits of a diverse student body. Thus, in the years since Grutter, I have sought to understand exactly how racial diversity yields educational benefits. With nearly 50 years to develop their arguments, neither Harvard nor UNC, two of the foremost research institutions in the world, nor any of their amici can explain that critical link. Harvard, for example, offers a report finding that meaningful representation of racial minorities promotes several goals. Only one of those goals, producing new knowledge stemming from diverse outlooks, bears any possible relationship to educational benefits. Yet it too is extremely vague and offers no indication that, for example, student test scores increased as a result of Harvard's efforts toward racial diversity. More fundamentally, it is not clear how racial diversity, as opposed to other forms of diversity, uniquely and independently advances Harvard's goal. This is particularly true because Harvard blinds itself to other forms of applicant diversity, such as religion. It may be the case that exposure to different perspectives and thoughts can foster debate, sharpen young minds, and hone students' reasoning skills. But it is not clear how diversity with respect to race, qua race, furthers this goal. Two white students, one from rural Appalachia and one from a wealthy San Francisco suburb, may well have more diverse outlooks on this metric than two students from Manhattan's Upper East Side, attending its most elite schools, one of whom is white and other of whom is black. If Harvard cannot even explain the link between racial diversity and education, then surely its interest in racial diversity cannot be compelling enough to overcome the constitutional limits on race consciousness. UNC fares no better. It asserts that, for example, an interest in training students to live together in a diverse society, this may well be important to a university experience, but it is a social goal, not an educational goal. See Grutter, Justice Scalia concurring in part and dissenting in part, criticizing similar rationales as divorced from educational goals. And again, UNC offers no reason why seeking a diverse society would not be equally supported by admitting individuals with diverse perspectives and backgrounds rather than varying skin pigmentation. Nor have amici pointed to any concrete and quantifiable educational benefits of racial diversity. The United States focuses on alleged civic benefits, including increasing tolerance and decreasing racial prejudice. Yet, when it comes to educational benefits, the government offers only one study purportedly showing that college diversity experiences are significantly and positively related to cognitive development, and that interpersonal interactions with racial diversity are the most strongly related to cognitive development. Here again, the link is, at best, tenuous, unspecific, and stereotypical. Other amici assert that diversity, generally, fosters the even more nebulous values of creativity and innovation, particularly in graduates' future workplaces. Yet none of those assertions deal exclusively with racial diversity, as opposed to cultural or ideological diversity, and none of those amici demonstrate measurable or concrete benefits that have resulted from universities' race-conscious admissions programs. Of course, even if these universities had shown that racial diversity yielded any concrete or measurable benefits, they would still face a very high bar to show that their interest is compelling. To survive strict scrutiny, any such benefits would have to outweigh the tremendous harm inflicted by sorting individuals on the basis of race. See Cooper v. Aaron. Following Brown, law and order are not here to be preserved by depriving the African American children of their constitutional rights. As the court's opinions in these cases make clear, all racial stereotypes harm and demean individuals. That is why only those measures the state must take to provide a bulwark against anarchy or to prevent violence will constitute a pressing public necessity sufficient to satisfy strict scrutiny today. And then see, for example, Lee v. Washington with Justice Black concurring, protecting prisoners from violence might justify narrowly tailored discrimination, and Crossan, at least where state or local action is at issue, only a social emergency rising to the level of imminent danger of life and limb can justify racial discrimination, quoting Justice Scalia. For this reason, just as the alleged educational benefits of segregation were insufficient to justify racial discrimination in the 1950s, the alleged educational benefits of diversity cannot justify racial discrimination today. The court also correctly refuses to defer to the university's own assessments that the alleged benefits of race-conscious admissions programs are compelling. It instead demands that the interests universities view as compelling must be capable of being subjected to meaningful judicial review. In other words, a court must be able to measure the goals asserted and determine when they have been reached. The court's opinion today further insists that universities must be able to articulate a meaningful connection between the means they employ and the goals they pursue. Again, I agree. Universities' self-proclaimed righteousness does not afford them license to discriminate on the basis of race. In fact, it is error for a court to defer to the views of an alleged discriminator while assessing claims of racial discrimination. See, for example, United States v. Virginia, refusing to defer to the Virginia Military Institute's judgment that the changes necessary to accommodate the admission of women would be too great and characterizing the necessary changes as manageable. We would not offer such deference in any other context, in employing discrimination lawsuits under Title VII of the Civil Rights Act. For example, courts require only a minimal prima facie showing by a complainant before shifting the burden onto the shoulders of the alleged discriminator employer. And Congress has passed numerous laws, such as the Civil Rights Act of 1875, under its authority to enforce the 14th Amendment, each designed to counter discrimination and each relying on courts to bring a skeptical eye to alleged discriminators. This judicial skepticism is vital. History has repeatedly shown that purportedly benign discrimination may be pernicious, and discriminators may go to great lengths to hide and perpetuate their unlawful conduct. Take, for example, the university respondents here. Harvard's holistic admissions policy began in the 1920s when it was developed to exclude Jews. Based on de facto quotas that Harvard quietly implemented, the proportion of Jews in Harvard's freshman class declined from 28% as late as 1925 to just 12% by 1933. During the same period, Harvard played a prominent role in the eugenics movement. According to then President Abbott Lawrence Lowell, excluding Jews from Harvard would help maintain admissions opportunities for Gentiles and perpetuate the purity of the Brahmin race, New England's white Protestant upper crust. UNC also has a checkered history, dating back to its time as a segregated university. It admitted its first black undergraduate students in 1955, but only after being ordered to do so by a court, following a long legal battle in which UNC sought to keep its segregated status. Even then, UNC did not turn on a dime. The first 3 black students admitted as undergraduates enrolled at UNC, but ultimately earned their bachelor's degree elsewhere. To the extent past is prologue, the university respondents' histories hardly recommend them as trustworthy arbiters of whether racial discrimination is necessary to achieve educational goals. Of course, none of this should matter in any event. Courts have an independent duty to interpret and uphold the Constitution that no university's claimed interest may override. The court today makes clear that in the future, universities wishing to discriminate based on race in admissions must articulate and justify a compelling and measurable state interest based on concrete evidence. Given the strictures set out by the court, I highly doubt any will be able to do so. In an effort to salvage their patently unconstitutional programs, the universities and their amici pivot to argue that the 14th Amendment permits the use of race to benefit only certain racial groups, rather than applicants writ large. Yet this is just the latest disguise for discrimination. The sudden narrative shift is not surprising, as it has long been apparent that diversity was merely the current rationale of convenience to support racially discriminatory admissions programs. Under our precedents, this new rationale is also lacking. To start, the case for affirmative action has emphasized a number of rationales over the years, including 1. Restitution to compensate those who have been victimized by past discrimination, 2. Fostering diversity, 3. Facilitating integration and the destruction of perceived racial castes, and 4. Countering long-standing and diffuse racial prejudice. Again, this court has only recognized one interest as compelling, the educational benefits of diversity embraced in Grutter. Yet, as the universities define the diversity that they practice, it encompasses social and aesthetic goals far afield from the education-based interests discussed in Grutter. The dissents to attempt to stretch the diversity rationale, suggesting that it supports broad remedial interests. See the opinion of Sotomayor, noting that UNC's black admission percentages do not reflect the diversity of the state, equating the diversity interest under the court's precedents with a goal of integration in higher education more broadly and warning of the dangerous consequences of an America where its leadership does not reflect the diversity of the people. And then see the opinion of Justice Jackson, explaining that diversity programs close wealth gaps. But language, particularly the language of controlling opinions of this court, is not so elastic. See Piper, abusive language, and then abuse of power, explaining that propaganda, in contradiction to the nature of language, intends not to communicate but to manipulate and becomes an instrument of power. The court refuses to engage in this lexicographic drift, seeing these arguments for what they are, a remedial rationale in disguise. As the court points out, the interest for which respondents advocate has been presented to and rejected by this court many times before. in regions of University of California versus Bakke, the University of California made clear its rationale for the quota system it had established. It wished to counteract effects of generations of pervasive discrimination against certain minority groups. But the court rejected this distinctly remedial rationale, with Justice Powell adopting in its place the familiar diversity interest that appeared later in Grutter. The court similarly did not adopt the broad remedial rationale in Grutter, and it rejects it again today. Newly and often minted theories cannot be said to be commanded by our precedents. Indeed, our precedents have repeatedly and soundly distinguished between programs designed to compensate victims of past governmental discrimination from so-called benign race-conscious measures, such as affirmative action. To enforce that distinction, our precedents explicitly require that any attempt to compensate victims of past governmental discrimination must be concrete and traceable to the de jure segregated system, which must have some discrete and continuing discriminatory effect that warrants a present remedy. Today's opinion for the court reaffirms the need for such a close remedial fit, hewing to the same line we have consistently drawn. Without such guardrails, the 14th Amendment would become self-defeating, promising a nation based on the equality ideal but yielding a quota and caste-ridden society steeped in race-based discrimination. Even Grutter itself could not tolerate this outcome. It accordingly imposed a time limit for its race-based regime, observing that a core purpose of the 14th Amendment was to do away with all governmentally imposed discrimination based on race. The court today enforces those limits, and rightly so. As noted above, both Harvard and UNC have a history of racial discrimination, but neither have even attempted to explain how their current racially discriminatory programs are even remotely traceable to their past discriminatory conduct. Nor could they. The current race-conscious admissions programs take no account of ancestry and, at least for Harvard, likely have the effect of discriminating against some of the very same ethnic groups against which Harvard previously discriminated, i.e., Jews and those who are not part of the white elite. All the while, Harvard and UNC ask us to blind ourselves to the burdens imposed on the millions of innocent applicants denied admission because of their membership in the currently disfavored race. The Constitution neither demands nor permits such a result. Purchased at the price of immeasurable human suffering, the 14th Amendment recognizes that classifications based on race lead to ruinous consequences for individuals and the nation. Consequently, all racial classifications are inherently suspect and must be subjected to the searching inquiry conducted by the court. So we'll stop there for now, and I'll have the next parts out in the next few days. And as always, if there's any case you'd like me to read, just drop in the comments and have a take a look. Thank you.